In this screencast, we'll discuss the Texas Code of Criminal Procedure requirements for search warrants for contraband. Just a few quick reminders. First, contraband in terms of the CCP is not the same as jail or prison contraband. In general, contraband is the proceeds or indirect benefits of committing a crime. Next, in previous screencasts, we also noted the best way to understand Code of Criminal Procedure requirements related to search warrants is to mentally organize all the things the CCP permits a search warrant to search for into 4 groups. All but one of these categories of things are numbered under CCP 18.02. The groups themselves are not found in the CCP, but keeping them mentally organized in this manner will help you understand and keep the differences straight in your mind. We've previously discussed this top group, which might be considered the general or catch-all category, and the very important and somewhat complicated requirements for 1802 parenthetical A, parenthetical 10, sometimes known as mere evidence in this group. Now we're going to talk about 1802 parenthetical A, parenthetical 12, which is contraband. The good news is, many of the complicated requirements for mere evidence under 1802 parenthetical A, parenthetical 10 that we've reviewed in a previous screencast also apply to contraband. If you haven't watched the screencast on search warrants for mere evidence, which immediately precedes this one, I strongly encourage you to do so. First, remember contraband subject to forfeiture through the search warrant under Chapter 59 of the CCP includes property of any nature, including real, personal, tangible, or intangible property used in commission of certain offenses, intended for use in the commission of certain offenses, or is a direct or an indirect benefit of the commission of certain offenses. According to the Code of Criminal Procedure 18.01 parenthetical G, a search warrant may not be issued for contraband unless the affidavit sets forth sufficient facts to establish probable cause a specific felony offense has been committed, the specifically described property or items to be searched for or seized constitute contraband as defined in CCP 59.01, which is the article covering definitions of contraband, and are located at or on the particular person, place, or thing to be searched. This is exactly the same as the search warrant requirements for mere evidence. Also the same as mere evidence, CCP 18.01 parenthetical H states, with exceptions that are outlined under 1801 parenthetical I, only certain magistrates may sign search warrants for contraband. The magistrate signing this type of search warrant may only be a judge of a municipal court of record or a county court who is an attorney licensed by the state of Texas, a county court at law judge, a district court judge, a judge of the Texas Court of Criminal Appeals, or a justice of the Supreme Court of Texas. Also the same as mere evidence, according to CCP 18.01 parenthetical I, in a county that does not have a judge of a municipal court of record, or a county court who is an attorney licensed by the state of Texas, or a county court at law judge, any magistrate may issue a search warrant for contraband. Finally, and again the same as mere evidence, a peace officer cannot request and a magistrate cannot order a search warrant for contraband that is located in an office of a newspaper, news magazine, television station, or radio station.